take 26 weeks or 175 days worked for an employee to be eligible to use paid family leave. That's a little bit different question from who has to contribute to paid family leave insurance. You hire an employee, let's say full-time, who's expected to work 40 or so hours a week indefinitely throughout their employment. From day one of their employment, you can take their contribution for paid family leave insurance out of their pay, even though they won't be eligible to use paid family leave unless and until they remain employed for 6 months. There is the possibility for some employees to waive coverage, which would mean that they don't get that portion of the paid family leave premium deducted from their pay. The benefits are paid by the insurance company, and the insurance companies charge premiums, but employers are entitled to deduct the full premiums from their employees' pay. So it's supposed to be an employee paid system, even though technically the employer is paying the premiums, the insurance company is paying the benefits, and the employees are paying the employer for the coverage. But there's no additional premium beyond what is contributed by employees. So there is some reason why employees wouldn't necessarily want to be in the program, but they can only waive coverage if they will not meet the minimum time requirements. It doesn't mean they have not yet met it. It means they will not meet it. How does this work? The typical situation is someone who is hired specifically for a limited duration that will not reach 6 months or 175 days, depending on the schedule that they work. If you hire an intern or someone to work over the summer or just for a holiday break or some other specific short-term period, then the company needs to offer those people the opportunity to waive coverage. And if they then waive coverage, they will not make contributions and won't be eligible for paid family leave benefits. If they choose not to waive coverage for whatever reason, practically that would mean that they would be subject to having the premium contributions taken out of their pay, even though they will likely nonetheless not become eligible for paid family leave benefits. The employees start paying for paid family leave, or at least the employer has the right to start taking the deduction for paid family leave coverage out of the employee's pay immediately, even though it would be 6 months before the employee is entitled to participate. Again, it's an insurance program, so the point is that people are paying in even if they're not receiving and even if they're not eligible yet to receive the benefits. In the case where an employee has waived coverage, assuming they were able to because circumstances suggested they would never become covered, but something changes such that they will now meet the minimum eligibility requirements, the waiver will be automatically deemed revoked. Again, the way this works is if now you thought someone was only working for the summer, but you've extended their employment to be permanent or indefinite anyway, at that point in time, even though they have not yet worked 6 months, now that the expectation is that they will work 6 months or may work 6 months, at that point in time, they now are no longer deemed to have waived coverage. So again, the contributions can start being made even though they're not yet eligible immediately to take paid family leave. These may revoke a waiver at any time. So why I say qualified employees here, assuming they're still eligible for a waiver, but for some reason decide they want to revoke it, they have that right. It's not clear why anyone in that situation would, because again, the expectation would still have to be that they're never going to be eligible for the benefits. If the waiver is revoked, the employer may begin taking payroll deductions and moreover can go back and make deductions retroactive from the date of hire. So whatever the appropriate contribution deduction would have been, say even over the last 2 or 3 months, can now be taken out once the waiver is revoked, either deliberately by the employee or just because a schedule change means that they're no longer eligible for waiver revocation.